morning. My name is Harris Gilbert from the law offices of Gilbert and Smallman. Last week I spoke a little bit about the prosecution's initial closing argument, and then I went through 3.6F, justifiable use of deadly force, and spoke about how it relates to the George Zimmerman trial where the victim was Trayvon Martin. Now, after I spoke, the defense lawyer, Mark O'Mara, then gave his closing argument. I thought he did a nice job. I thought he laid out the law of justifiable use of deadly force for the jury. He went through all of the facts, and in fact, he actually, which was a non-traditional approach, told the jury that he was going to, in effect, take a shot at proving his client's innocence. And the way he did that was he went through all of the evidence and he brought up reasonable doubt. And in addition, he went through a chart which basically shows that unless there was no reasonable doubt, meaning if the jury was feeling that more likely than not or probably that it happened where there was no justifiable use, that it wasn't enough according to the law. And this is a reasonable doubt chart. It's a technique that criminal defense lawyers often use. We use it in jury selection. We use it in closing arguments, kind of tie everything together. And he, through his summation, his closing argument, also did a couple powerful, I thought, techniques. One was he presented an argument that there was a 4-minute gap between when Trayvon could have went home when he was spotted by George Zimmerman and when the incident was reported by someone in the neighborhood. And in order to emphasize that length of time, basically to show that Mr. Trayvon Martin hung around and George Zimmerman interacted with him, he sat down at the defense table for 4 minutes. Now, when you think of 4 minutes through the course of a day, normally you think about it, it's not that long of a period of time. However, when you're sitting in a courtroom for 4 minutes, basically doing nothing, it seems like an hour. So after the 4 minutes, he stood up and he presented to the jury that was the amount of time that Trayvon Martin had to, in fact, just go home that night instead of hanging around outside. And then he took a break. When he came back from the break, he then went through each of the witnesses through slides. He put up pictures of them, some notes about them, who they were, what they said during the trial. And the contention of the prosecution was that Trayvon Martin was unarmed. So to show that the wounds that had been inflicted came from something that was significant, Mark O'Mara then went to the defense table, grabbed a huge brick of concrete and brought it and placed it in front of the jury and submitted to the jury that when used in the context that they had proposed, that slab of concrete certainly could have caused death or great bodily harm. And he went through the jury instruction. He talked about the subjectivity, how what a reasonable and prudent person in the same circumstances of George Zimmerman would react. And as a result, I think those were some powerful things for the jury to think about. Now, after the close of the defense, then came the final rebuttal argument from the prosecution. Now, for those of you who don't know, in the state of Florida, we have what's known as a sandwich, where the prosecution goes, give their closing argument, then follows the defense closing argument. And after that, the prosecution is allowed to come back with what's known as a rebuttal, where they save a certain allotted period of time in order to refute the arguments of the defense. And that's just the way the state of Florida sets up their criminal justice system. So in this circumstance, there was a rebuttal argument, and that argument was done by another prosecutor. It wasn't done by the one who originally gave the closing argument. It was done by a second one who was a little younger. I thought he did a very nice job, basically portraying Trayvon Martin as a young boy, as a victim, George Martin as George Zimmerman as an aggressor with hate in his heart, ill will, all the things that they needed to prove in order to prove murder too, and kind of pulling on the jury's heartstrings as Trayvon Martin as a young boy and a victim. Now, they submitted the case to the jury Friday around 2 o'clock. The jury got their instructions from the court, and they went back and deliberated for several hours on Friday. Then on Saturday, which was unusual, a lot of people were surprised that they didn't come back on Monday, but in this case, the jury was sequestered, so it was kind of not your normal circumstance. They worked through Saturday. Saturday they came back in the morning, and they actually deliberated all day Saturday and didn't come with a verdict until later in the day at about 10 o'clock p.m. So, as most of you probably know, the verdict came back not guilty. Now, briefly, I just want to say that regardless of what happened with the jury, that it's a terrible tragedy for a young man to die in the way that he died. And I don't think that we can really get beyond that, and that regardless of the verdict, we all hope that people learn something, that the next person who's in George Zimmerman's position will choose to stay in the car instead of disobeying instructions from the police and going out there on his own. Because the truth is that if George Zimmerman stays in his car, that this never happens. Now, as we know, he got out and the incident happened. But regardless, it's a terrible tragedy for someone 16, 17 years old like Trayvon Martin to have died in the manner that he did way too early. And my heart goes out to his family and to anyone associated with him. It certainly is a terrible tragedy. Now, just taking a look at the case from a legal standpoint, trying to understand the roles of everyone. The jury is the finder of fact. The judge is the finder on the law. The defense lawyer argues for the defense. The prosecution argues for the state. Now, as a defense lawyer, I'm often questioned as to, how I can represent someone if I know that they've killed someone. That I know that something has happened. And as I grew into becoming a trained defense lawyer, not only did I have the opportunity to start from ground level and work my way up, but I also read a great book once by the great defense lawyer Alan Dershowitz, who is one of O.J. Simpson's defense lawyers. It is called Letters to a Young Lawyer. Now, if any of you were in law school or just interested in the criminal justice system, I recommend you read this book. Basically, what Mr. Dershowitz states in the book is that everyone has a role in the criminal justice system. And that as a defense lawyer, in order to do your job and to do it well, and then to leave at the end of the day and come back the next day, you have to understand that your role is just one of several in a wheel. Now, as the defense lawyer, you are the megaphone to the defendant. So whatever the defendant's contention is, you are there to exude it to a judge, to a jury, to a prosecutor. And the state, in the same way, they are there to argue on behalf of the state. Now, we have to have faith in our system. And our system was set up hundreds of years ago by some very intelligent men, the Founding Fathers. And the faith in our system relies on the judge and on the jury. The judge to make the correct decisions about what legally should be decided, what information should go to a jury, what the jury should have in front of them to make a decision. And then the jury, 6 people, normally non-lawyers, are the finders of fact. It's their job to take the facts as presented to them, find which ones that were presented that they should lend credence to, and to make a decision. So in this case, regardless of the outcome, the legal system has spoken. George Zimmerman was found not guilty on all counts. So with that, Mr. Zimmerman leaves the courtroom, leaves the jail, and attempts to pick up the pieces and move on with his life. To his defense counsel, we think they did a fine job. To the prosecution, I think they did a fine job as well, given the facts they were presented with. They did not have a lot of evidence to work with, And in these cases where the evidence is circumstantial or in conflict with each other, oftentimes that will favor the defendant, and that's the way that our system is set up. A lot of people have said that the stand your ground law is one that needs to be changed. Just as an attorney analyzing the case, the law that was applied was the law of self-defense, not necessarily stand your ground. And stand your ground was a motion that was made in the beginning as a precursor to the trial. In the trial, it's the 3.6F justifiable use of deadly force that was used. So, this law has been in effect as long as I've been an attorney. There haven't really been any significant modifications. And on a case-by-case basis is how it needs to be interpreted. Now, at Gilbert and Smallman, we take pride in representing criminal defendants, personal injury plaintiffs, people being foreclosed on, people charged with DUI, people charged with traffic offenses, and we fight vigorously for all of them, because that is our job as defense counsel, to be your megaphone. So if you or a loved one is in need of an attorney for a criminal defense matter, for a personal injury matter, for a real estate matter, know that you can come to myself or Andrew Smallman at the law offices of Gilbert and Smallman, and we're here for you. We will provide you a free initial consultation. We're available 24/7. We give out our cell phones to all of our clients. We make ourselves readily available. If you have a question and I'm your lawyer, I don't want you to wait through the weekend and not sleep. I want you to call me on Saturday to talk to me for a couple minutes, for me to ease your mind about your question, and then for us to readdress it next week, or if there's an emergency, for us to address it right then. And in my opinion, when your life is on the line, whether it be because you are arrested or charged or injured, or your home is possibly going up on foreclosure, it is very important to have an attorney that's accessible, and that is one thing that we take great pride in at the law offices of Gilbert and Smallman. So once again, thank you for listening to some of my thoughts on the George Zimmerman trial, and once again, my heart goes out to the family of Trayvon Martin. And if anyone is in need of a good lawyer, please don't hesitate to contact us. Once again, Harris Gilbert, the law offices of Gilbert and Smallman, PLLC, serving people across the state of Florida in federal and state cases in several practice areas. You can visit our website, www.hgilbertlaw.com, for more information. We blog, we Facebook, we tweet, and we're here for you if you need us. Have a great day.